Hello everyone. Today I'm going to represent my topic that was the advisory opinion of International Court of Justice on Nuclear Weapons 1996. Here we are going to look into three things in this case. First one was the background of the ICJ, which he has given in his judgment in 1996. Second were the facts, and third the issues involved in it. First of all, when we go about the background of the case, on July 8, 1996, the ICJ, which we also known as World Court, delivered two advisory opinions on separate requests received from the WHO and the General Assembly of United Nations. The principal organ of the United Nations, who form an integral part of the 15 judges representing different regions of the world or the globe, we can say. In addition to the court delivering judgment in convention cases submitted to its state, it may issue non-binding advisory opinions at the request of the certain UN organs and the agencies. In determining the legality and illegality of the threat and the use of the nuclear weapons, ICJ here described the two questions which were involved in it. The number one question was the provision of the United Nations Charter relating to the threat or the use of the force. Here the word use of the force or the threat we are going to discuss in detail in next slides. Second one, the principles and the rules of the ICJ and the international humanitarian law, which we also known as a law of armed conflict, international armed conflict, that forms a part of the applicable in the armed conflict or neutrality. The third one was the any relevant specific treaties on nuclear weapon in applying in any law in any form or any kind are allowed or not. Number one, the court first considered the provision of United Nations Charter, as I mentioned earlier in previous slides. Although Article 2.4 of the United Nations Charter prohibits the threat or the use of the force, and also Article 51, which we all know recognize every state inherent right of individual or collective defense in armed force occurs. And Article 42 authorizing Security Council to take military enforcement measures don't recover to specify weapons. The court had that they apply to use any of the force regarding of any weapon employed. Here the concept of the court was very neutral. Prospectively, the court noted that UN Charter neither specifically prohibits or permits, which means UN Charter there is nothing specific mentioned in the UN Charter regarding the use of the weapons, and and any treaty or any custom does not become unlawful by the reasons of it being used for legitimate purpose under this charter. Now we are going to discuss the compatibility with international humanitarian law and other laws relating to this advisory opinion of ICJ. The UN Charter, though the UN Charter neitherly express or permits, as I mentioned in earlier slides, the use of the weapons, these use of the weapons shall be proportionate to the armed attack and necessary. These principles of proportionate and neutrality we will going to discuss in the next few slides. International humanitarian law. The court is of the opinion that even if the use of the nuclear weapon is lawful, still it must comply with the provisions of law applicable to the armed conflict, humanitarian law, and other laws. Second situation which we have discussed previous was the situation of self-defense, which was defined in under Article 51 of the UN Charter. There are certain restrictions to the right of self-defense. Firstly, for the act considered to be act of self-defense, the use of force be in self-defense only. Secondly, The defending state is required to report the measures taken in order to protect itself to the Security Council of the United Nations. And last but not the least, the measures taken for the self-defense must be in conformity with the customary international principles of necessity and proportionality. The promotion of nuclear disarmament, whether this nuclear disarmament are promoted or not. After the critical analysis, the court is in the opinion that the state shall continue to have negotiations and agreements toward nuclear disarmament for environment protection and human welfare. Here, the court has described the two things that this can be done for the environment protection and human welfare. The states are legally to go through the negotiation that brings nuclear disarmament. Now, we are going to discuss in detail about the principle of neutrality. The principles of neutrality is one of the most customary international law which is imperative to be considered while talking about the armed conflicts. Neutrality, what is neutrality? Neutrality is a formal status given to a state which is not a party to an armed conflict. This principle gives rise to rights and duties of both neutral and belligerent state. Belligerent state here refers to the state which has been declared as a state who has attacked on the other state. Just like, for example, we can consider Pakistan as a belligerent state as it provokes other countries to do any acts. It is imperative to take the principle of neutrality into consideration while discussing the legality or the use of the nuclear weapons. Second was environmental laws and self-defense. A balance should be drawn between environmental laws and right to self-defense. It is indispensable on the part of the state to take environmental consideration into account in order to measure the degree of the necessity and proportionality as we have discussed in previous slides. So even if the use of nuclear weapon is not legal, one should respect the environment law by complying with it. Ban on testing of the nuclear weapons. Here the three bans and the treaties which promote nuclear armaments and protect the environment relations, these treaties are specifically given here. The treaties are Nuclear Non-Proliferatory Treaty, Limited Test Ban Treaty (LTBT), Comprehensive Test Ban Treaties. Now at last we reach to the final conclusion of our slides. Wrapping up, I would like to highlight that despite various steps which have been taken to promote complete disarmament, there is no absolute rule which absolutely provides the right of force or threat of nuclear weapon. Having said that, it is imperative to take strict measures to control the use and take the nuclear weapons so that the environment can be least affected and health hazards due to the radiation of these weapons can be reduced. Thank you.